The man accused in the tragic University of Idaho murders, Brian Kohberger, has once again made headlines from behind bars. During a recent court appearance, he confirmed his involvement in the deaths of the four students, including Kaylee Gunkov's, an event that shook the small community of Moscow, Idaho. But even now, Kohberger continues to cause pain for the victims' families. His legal team is pushing new arguments in court, trying to limit what he has to pay in connection with the case. These ongoing disputes have left many wondering when the families will finally see justice and closure after everything they've endured. You might think that after admitting to one of the most shocking crimes in recent memory, the murders of four University of Idaho students, Brian Kohberger would finally fade from the spotlight. After all, he confessed to entering the home on King Road in Moscow, Idaho on November 13, 2022, and taking the lives of Madison Mogen, Kaylee Gunkov's, Zana Kernodle, and Ethan Chapin. He also pleaded guilty to burglary and received 4 consecutive life sentences without the possibility of parole. But even behind bars, Kohberger's name continues to surface, this time because of a new legal dispute that's reopening old wounds for the victims' families. His defense team is now arguing that he shouldn't have to pay any additional restitution, claiming that the families have already received financial support through community fundraising efforts, like GoFundMe. Here's what's going on. When Kohberger entered his guilty plea, the court ordered him to pay restitution, a form of compensation meant to help cover the costs endured by victims and their families. Both the prosecution and defense initially agreed on a payment of roughly $29,000. That included about $14,000 owed to Idaho's Crime Victims Compensation Program, which helps families with medical and counseling costs, along with nearly $6,000 for Jim and Stacy Chapin and just over $8,800 for Jeffrey Kernodle. However, prosecutors later requested an additional $20,000 for Kaylee Gunkov's parents, Steve and Christy, and nearly $7,000 for Madison Mogen's mother, Karen Laramie. Those amounts were reportedly tied to travel and accommodation expenses related to the case. Kohberger's legal team is pushing back, saying those extra payments shouldn't be required. Kohberger's defense team is pushing back hard against the state's request for more restitution. In their recent court filing, titled Defendant's Objection to the State's Request for Additional Restitution, they argue that the plea agreement already made the payment terms perfectly clear. According to them, Kohberger agreed only to specific restitution categories, and once all verified receipts were submitted, those obligations were fulfilled. The defense claims the prosecution is now overstepping what was originally agreed upon, insisting that the state must honor the terms laid out in the plea deal. They also highlight Idaho's legal definition of economic loss, which typically covers property damage, medical costs, lost wages, or other direct financial impacts caused by a crime, but does not include things like emotional distress or pain and suffering. Building on that point, the defense argues that the families have already received substantial financial support through community fundraising efforts. They reference multiple GoFundMe pages that reportedly raised tens of thousands of dollars. One campaign for Madison Mogen and Kaylee Gunkov's that collected more than $70,000. Another for Madison's mother that brought in nearly $50,000. And a separate fundraiser for Kaylee's parents that surpassed $80,000. Using these examples, Kohberger's lawyers claim that the families did not experience additional economic loss as defined by state law. They also argue that Kohberger simply doesn't have the financial ability to pay more. Citing Idaho law, they note that restitution must consider both the needs of the victims and the earning capacity of the defendant. And in this case, their client has no means to contribute beyond what's already been agreed upon. Kohberger's defense went on to argue that he simply has no means, now or ever, to pay additional restitution. They pointed out that he's serving 4 consecutive life sentences plus an additional 10 years, meaning he has no opportunity to earn income or generate money of any kind. The filing compared his case to others in Idaho, where inmates serving shorter sentences were ordered to pay restitution. Kohberger's situation, they claim, is different. He'll spend the rest of his life in prison and will never have the financial ability to make further payments. His attorneys also referenced Idaho state law, which prevents convicted offenders from making money through books, movies, or any form of entertainment about their crimes. Even if someone were to enter a contract with him for a film or documentary, any money generated would legally go to the state treasurer, who would then place those funds in an account designated for the victims. In short, the defense summarized their argument with three main points. 1. The original plea agreement already included specific restitution amounts covering funeral costs and reimbursement through Idaho's Crime Victim Compensation Fund, roughly $29,000 in total. 2. The extra payments requested by prosecutors don't qualify as economic loss under Idaho law because the families have already received significant financial support through various fundraising efforts. 3. Kohberger has no ability, now or in the future, to earn or pay additional restitution due to his life sentences. Because of these reasons, the defense formally objected to any further payment requests and even asked that Kohberger not be transported for any hearings on the issue, allowing his legal team to appear on his behalf. After this filing, the question many people are asking is, does the defense have a valid argument? To help break that down, legal expert and former prosecutor Mark Weaver joined the discussion. Weaver explained that restitution is typically guided by state law, and most states have compensation programs that assist crime victims and their families with expenses related to the case. Mark Weaver went on to explain how restitution typically works in cases like this. In most situations, courts want the person responsible for the crime to contribute financially to the victim's compensation fund. However, that's rarely realistic. The people behind the most violent crimes often have no financial resources at all, and that seems to be exactly what's happening in this case. When it comes to the actual amount of restitution, Weaver explained that it varies widely depending on the circumstances. These funds aren't designed to replace a civil lawsuit. They exist mainly to help victims and their families recover direct, out-of-pocket costs related to the crime. That might include things like travel expenses, hotel stays, counseling, or time missed from work. In contrast, civil lawsuits are where families might pursue additional damages, including emotional distress or punitive compensation. The conversation then turned to a difficult question: how often can offenders actually pay these restitution orders? Realistically, Weaver noted, very few ever do. Judges still impose them because it's part of the process, even when it's clear that most defendants will never have the money to pay. He gave an example from another case he handled, involving a child killed by a dog attack. In that case, the judge also ordered restitution and fines, even though it was understood that the defendant had no financial means to pay. In rare situations, if a convicted person somehow receives money later, whether from an inheritance, outside donations, or work programs, those funds can be seized and applied toward restitution. Weaver added that restitution makes more practical sense for inmates serving shorter sentences. If someone eventually re-enters society and resumes a career, they can be required to make regular payments, much like paying off a long-term debt. But for someone serving life in prison with no chance of release, the payments are largely symbolic. They exist on paper, but will likely never be made. Weaver continued by explaining how restitution usually works in most states. Typically, the state's Victim Compensation Fund covers the immediate costs for families, things like counseling, travel, or funeral expenses. Later, the state can try to recover that money from the person convicted of the crime. If that person ever earns an income again, the state can garnish part of their wages, place liens on their property, or collect money from any future assets. But when someone is serving a life sentence, like Brian Kohberger, that process becomes almost impossible. He has no job, no source of income, and no chance of release, which makes this case particularly complicated. Under Idaho law, Kohberger also can't profit in any way from the crimes he committed. That means he can't sell interviews, write a book, or take part in any documentary or project that would generate income. Even if he tried, the law states that any money earned would go directly to the state treasurer and be placed in an account for the victims' families. These laws are often referred to as Son of Sam laws, named after a notorious New York case from the 1970s, where the killer attempted to profit from telling his story. Some states have faced legal challenges to these laws, arguing that they restrict free speech. For instance, If an inmate takes up art or writing as a personal hobby and tries to sell their work, not connected to the crime itself, their lawyers could potentially claim it's a violation of their First Amendment rights. Weaver explained that while those scenarios are rare, they do raise interesting legal questions. In theory, a remorseful inmate could try to help victims' families by voluntarily directing any money they earn toward them. But in this particular case, there's been no indication that Brian Kohberger feels any remorse or intends to take such actions. From a broader perspective, this latest motion by the defense, arguing against additional restitution, leaves many people uneasy. For families who have already suffered unimaginable loss, the effort to block even symbolic payments comes across as insensitive and self-serving. Many people have described this legal filing as completely tone-deaf. After everything these families have endured, the idea that Kohberger's defense team is still fighting to reduce or avoid restitution payments feels deeply insensitive. These parents have already lost their children, and now even symbolic financial acknowledgement of that loss is being challenged in court. It also raises a practical question: who's actually paying these lawyers? Kohberger is serving multiple life sentences with no possibility of release. He has no money, no assets, and no way to generate income. So why continue fighting over restitution that, realistically, he'll never be able to pay? As one legal expert pointed out, yes, attorneys have a duty to explore every possible argument for their clients. But from a human perspective, the move sends a troubling message. It gives the impression that Kohberger and his defense team have learned nothing from this tragedy and are unwilling to take even symbolic responsibility. When it comes to restitution, travel and accommodation costs are often considered legitimate expenses for victims' families. They wouldn't have to attend court hearings, stay in hotels, or travel across states if the crime had never happened. These are exactly the kinds of direct, out-of-pocket losses that compensation funds are designed to cover. Still, the financial support available to families through state programs is usually minimal compared to the enormity of their loss. These funds help ease the burden, but they can't begin to replace what's been taken from them. The biggest controversy here lies in the defense's argument that the families shouldn't receive additional compensation because they already benefited from GoFundMe campaigns. Legally, that may be a technical argument, but ethically it comes across as cold and dismissive. No amount of crowdfunding can cover the emotional and financial toll of losing a child, and every family has the right to be present, to seek justice, and to find some measure of closure in court. Some of the victims' families even had to hire their own lawyers to protect their privacy and help them navigate the legal process. Another clear example of out-of-pocket costs directly tied to this case. Expenses like that go far beyond travel or lodging, and they show how deeply the financial impact of these crimes still runs. From a human standpoint, the entire defense filing feels tone-deaf. Even though attorneys are doing their jobs, many people can't help but see it as a moral misstep, because arguing that grieving families have already received enough through GoFundMe donations just doesn't sit right. It sends the wrong message, both ethically and publicly. Now, from a purely legal perspective, the question becomes more technical. If the case lands before a judge, could the defense actually succeed in arguing that the GoFundMe funds should offset restitution? Judges are supposed to look at facts and law, not emotion, so technically it's possible. But most legal experts believe that would be an extremely narrow interpretation of restitution law. Judges are required to ensure restitution covers genuine, direct expenses resulting from the crime, like travel, lodging, therapy, or legal assistance. But they also have to be cautious not to overextend what qualifies. For instance, one judge once denied restitution for items like a new security system or a replacement pet after a burglary because those weren't considered direct, necessary losses. Still, GoFundMe donations are a new and complicated wrinkle. There isn't much legal precedent in the U.S. for how that money should be treated in criminal restitution cases. Should voluntary community donations be seen as offsetting what a convicted murderer owes? Or should they be completely separate, a gift from the public that doesn't erase the offender's responsibility? If this case sets new precedent, it could shape future rulings. But many legal observers believe that no matter how much was raised online, those funds don't cancel out the true financial and emotional cost endured by these families. The defense also points to the plea agreement, arguing that it already outlined the restitution amounts and categories both sides agreed to, and that the state shouldn't be allowed to expand those terms after the fact. In other words, their stance is a deal is a deal. Everyone who commits a crime in Idaho falls under Idaho's state laws, and that includes how restitution and victim compensation are handled. So no matter what Brian Kohberger's defense team argues, those rules still apply. Now, even though he agreed to pay certain fines and restitution amounts as part of his plea deal, the state can still pursue additional compensation within the legal limits. Realistically, though, this is mostly symbolic. Kohberger doesn't have any significant assets, just a small prison commissary account. By law, only about 20% of that can be taken for restitution. Some say it should be the other way around, that inmates should keep 20% and victims should receive 80%. But again, Idaho law governs what can and can't be done. There's another complicated issue, too. If Kohberger ever receives outside money, say from supporters or sympathizers sending donations, could that money be redirected to the victims' families? Possibly, yes. Depending on how Idaho's Son of Sam laws are written, any funds tied to notoriety from his crimes could be seized and funneled into a restitution pool. However, some of these laws have been challenged in court under the First Amendment, especially when they're too broad or restrict speech that isn't directly about the crime. Still, as disturbing as it is, history shows that even convicted killers sometimes attract fan bases, people who send letters, money, or even gifts. If that happens here, many believe the judge should direct any such funds straight to the victims. As for what happens next, this motion likely won't spark a full courtroom hearing. Instead, it'll probably be handled on paper. Each side submits written arguments, and the judge makes a ruling. It's not expected to drag on or take up much court time. But while we're talking about Kohberger, there's been another major development. His decision to plead guilty. It raised a lot of questions. Why plead now, after fighting for so long? The timing is telling. The plea came right after prosecutors revealed that his own sister, Amanda Kohberger, was expected to be called as a witness, both for the defense and as a mitigation witness during sentencing. There are likely multiple factors at play. For one, Kohberger's legal options were collapsing. The judge had already refused to throw out the DNA evidence and blocked him from blaming other suspects. And that part especially infuriated people, because just before pleading guilty, his defense had been preparing to suggest other innocent people were involved. Then suddenly he admits guilt. It makes it clear that tactic was nothing more than deflection. Still, some believe his guilty plea may have been partly motivated by his sister's involvement. Even the coldest defendants sometimes have a sliver of compassion for their families. And he may not have wanted to put her through the trauma of testifying. Prosecutors had also taken the death penalty off the table, another factor that often influences guilty pleas in high-profile murder cases. For the defense, avoiding execution can be the only win left. And honestly, it's probably for the best that this case didn't go to trial, because if it had, what the jury, and the families, would have had to see and hear would have been devastating. According to a recent report, Kaylee Goncalves' sister said that some of Kaylee's wounds appeared to have been inflicted after she stopped fighting back, and that investigators described them as experimental. That's horrifying to even imagine. And while many people wanted a public trial to see justice unfold, you have to wonder, would it have only deepened the family's pain? As one former prosecutor put it, jurors don't choose this. They're summoned, they show up, and they carry the emotional weight of what they witness. Prosecutors, defense attorneys, judges, they all signed up for this work, but the families and jurors, they didn't.